The Supreme Court chamber grew completely still as Congresswoman Jasmine Crockett stood before the council table. Her voice firm and calm despite being interrupted for the third time in 5 minutes by Justice Samuel Alito for months. The conservative justice had drawn public attention with a series of controversial appearances that raised doubts about his neutrality on key cases. On this day, as Crockett presented her arguments in a landmark voting rights case, Justice Alito's frustration was evident. "Congresswoman Crockett, that's not what the Constitution says," he interjected sharply, cutting her off mid-sentence. The crowded courtroom froze as Crockett stopped speaking, her expression unshaken. Slowly, she opened a brown leather portfolio that had remained untouched until then, removed a single paper, and began to speak in a calm yet commanding tone. What unfolded in the next 30 seconds didn't just silence Justice Alito. It revealed a moment that would echo through the federal judiciary for years before this defining exchange. Jasmine Crockett was already recognized as one of the most skilled legal minds to enter Congress. As a former public defender and civil rights lawyer with deep experience in voting rights litigation, she possessed a rare mastery of constitutional law. Though she now served in the legislative branch, she had kept her law license active and occasionally took on high-impact constitutional cases. This challenge to a restrictive state voting statute being one of them. Meanwhile, Justice Samuel Alito had been facing criticism for a series of partisan-leaning speeches. At a Federalist Society event just weeks earlier, he questioned the legitimacy of recent voting rights expansions, prompting concern about his ability to remain impartial in related cases. Multiple ethics complaints were submitted, yet the absence of a binding Supreme Court ethics code left them unresolved. The framers understood that election systems required safeguards, Alito had said in his speech. Modern claims that such measures are discriminatory would have baffled them. His comments drew widespread backlash from legal experts across the political spectrum for appearing to prejudge cases still pending before the court behind the scenes. Crockett had been preparing for months, not only refining her legal reasoning but also researching the historical context of the very constitutional provisions. Justice Alito often cited her dual perspective as both a legislator and a trained attorney gave her a unique advantage in bridging constitutional theory and real-world governance. The courtroom overflowed with civil rights advocates, journalists, and legal scholars. Because of the case's national significance, the Chief Justice had allowed extended argument time, and anticipation was intense. As Crockett stepped to the podium, whispers spread that Justice Alito, well known for his aggressive questioning of progressive lawyers, would likely dominate the exchange. Many expected another partisan confrontation typical of recent Supreme Court hearings. Instead, as she began her oral argument, the tension in the chamber was electric. Unlike past advocates who stumbled under pressure, Crockett opened with a clear and powerful narrative that focused on the human impact of the voting restrictions being contested. "Mr. Chief Justice, and may it please the court," she began steadily, "the right to vote is the cornerstone of every other constitutional protection. When 53,000 eligible citizens in Jefferson County were denied their ballots last November, it wasn't just a personal loss, it was a failure of our constitutional promise." A few justices nodded as she transitioned from moral clarity to constitutional precision. The state claims that Article 1, Section 4 grants them unlimited authority to control voting procedures, she continued. But that argument ignores both the 14th Amendment's equal protection clause and the historical understanding of its purpose. Justice Alito interrupted again, his tone curt and dismissive. "The text of Article 1 is quite clear," he insisted. "The Constitution gives state legislatures the primary power to regulate elections. Isn't your real disagreement with the constitutional design itself?" Justice Samuel Alito interrupted just 90 seconds into Jasmine Crockett's presentation. Despite the sharp tone, she stayed perfectly calm. "Justice Alito, my position isn't in conflict with the Constitution. It's about reading it in full," she replied evenly. Article I cannot be separated from the Reconstruction Amendments, which fundamentally redefined how authority is shared between the federal government and the states in matters of voting. She proceeded to carefully outline how the 14th and 15th Amendments directly limited state control over elections, referencing detailed records from Reconstruction era, congressional debates as well as key Supreme Court precedents that supported her interpretation. Justice Elena Kagan nodded in acknowledgement of the historical accuracy, while Justice Brett Kavanaugh jotted down notes. As Crockett advanced her argument, demonstrating how the voter ID rules being challenged placed unequal burdens on minority voters, Justice Alito broke in again. These are mere inconveniences, counsel, not constitutional violations, he said firmly. Every voting law carries some burden. Unless there's evidence of deliberate discrimination, which your data does not show, those choices belong to the states, not the federal courts. Crockett didn't flinch. With respect, Justice Alito, this court's decision in Anderson v. Burdick made clear that even in the absence of discriminatory intent, any voting rule that places an undue burden on the right to vote must be justified by a legitimate state interest, she answered. The evidence before us shows the supposed interest in preventing fraud has no factual foundation. Alito interrupted for the third time, visibly irritated. The Constitution doesn't guarantee convenience, Congresswoman. It distributes authority, and in elections, that power belongs primarily to the states. His pointed use of Congresswoman rather than counsel caused a stir in the courtroom, a rare break from Supreme Court decorum that appeared intended to highlight her political position rather than her legal. Standing, Crockett paused for a brief moment, meeting his gaze directly. The Constitution, Justice Alito, is not only about granting authority, it's about setting boundaries to preserve our most fundamental rights, she said. And since you've raised the issue of constitutional design, let's look at what history actually shows. She reopened her leather portfolio, removing a carefully marked document. I've reviewed the original congressional debates that shaped the Reconstruction amendments, focusing on how they address state powers over elections, she continued, her voice steady yet commanding. You've often argued, both in today's discussion and in recent public remarks, that the Constitution originally granted states nearly unlimited control over voting. But that's not what the framers of the 15th Amendment intended. Holding up the document, she read aloud from a highlighted section. Senator Oliver Morton, one of the key authors of the amendment, stated that its purpose was to place the power of protecting the right to vote in the rightful hands of the federal government, rather than leaving it to the discretion of states that have proven unworthy of that trust. The chamber went silent. Justice Alito shifted slightly in his chair as she continued. Representative James Garfield, who later became president, emphasized during those same debates that it was time to establish a constitutional principle strong enough to override all state laws that restrict voting rights for reasons unrelated to the act of voting itself, she said, turning to another page. And most directly relevant to this very case, she added, Senator William Stewart, who helped draft the 15th Amendment's language, specifically addressed whether states could impose procedural barriers that effectively nullify the right to vote. He declared, "We are not just creating a ban on racial barriers. We are establishing a positive principle that the right to vote must be genuinely available to all citizens, regardless of their background or position." As Congresswoman Jasmine Crockett read the words aloud, several justices, including Chief Justice John Roberts, leaned forward to examine the documents more carefully. She handed copies to the clerk for circulation. Justice Elena Kagan exchanged a quick, meaningful look with Justice Sonia Sotomayor. "These aren't obscure records." "Justice Alito," Crockett said, her voice now carrying greater force, "these are the direct statements of the very framers of the Reconstruction amendments, the same provisions you've quoted throughout today's hearing. Their words directly contradict the narrow interpretation you've presented here and in your recent public comments." Justice Samuel Alito's expression hardened, a trace of unease flickering across his face as he absorbed the implication. He leaned toward his microphone, ready to respond, but Crockett continued, her tone steady and deliberate. The historical record leaves no ambiguity. The Reconstruction Congress intentionally curtailed state control over elections, because they knew that laws appearing neutral on the surface could still be used to erode voting rights. They didn't stop at banning explicit racial discrimination. They went further, establishing an affirmative federal duty to ensure every citizen had real access to the ballot. Crockett then turned to the evidence from the case itself. In Jefferson County, 83% of those denied ballots under this law were minority voters. Even though minorities make up only 34% of the county's population, she said. That kind of disparity would have outraged the architects of the 15th Amendment, who specifically rejected the idea that states could use procedural rules to achieve what they were constitutionally forbidden to do outright. Justice Amy Coney Barrett, who had listened quietly until now, leaned into her microphone. Congresswoman Crockett, these historical records are powerful. How would you suggest the court incorporate them into our standard of review? Thank you, Justice Barrett, Crockett replied. These sources make it clear that when courts evaluate voting laws, they must apply heightened scrutiny whenever a rule results in significant disparities in access to the ballot, even if intentional discrimination can't be proven. The framers of the Reconstruction Amendments understood that the right to vote preserves every other constitutional right and deserves protection from procedural obstacles. Justice Alito tried to seize back control of the discussion. Counsel, these are interesting historical details, but they can't override the plain text of Article I, which still governs state authority over elections. With respect, Justice Alito, Crockett interjected calmly, these are not mere historical details. They are the official explanations of constitutional meaning given by the very lawmakers who wrote and ratified the amendments. Their intent was clear. The Reconstruction Amendments were designed to place boundaries on state powers, including those granted under Article I. She paused briefly, then delivered her closing point with precision. Those amendments reshaped the constitutional structure itself. They created new limits on state authority, specifically in the area of voting rights. To interpret Article I today as though those amendments never existed is not textualism or originalism. It's selective constitutionalism. The phrase fell with quiet intensity across the chamber. A few law clerks in the back row exchanged startled looks, while Justice Clarence Thomas, who rarely spoke, raised an eyebrow slightly. Recognizing the significance of the exchange, Chief Justice Roberts extended Crockett's time by 5 minutes, a rare gesture that underscored the impact of her argument. Crockett then methodically tied these historical principles back to the evidence in the record, showing how the state's voter ID law imposed exactly the kind of procedural barriers the Reconstruction framers sought to prevent. Concluding her remarks, she looked directly at the bench and said clearly, "This case isn't about convenience versus security, as some have claimed. It's about whether we honor the constitutional promise embedded in the Reconstruction Amendments, a promise that the right to vote must remain real, equal, and protected for every American, regardless of race, income, or status." As her allotted time ended, Congresswoman Jasmine Crockett gathered her papers and delivered one final sentence that left the courtroom utterly silent. The framers of the 15th Amendment would immediately recognize what is unfolding in Jefferson County today, she declared. The real question before this court is whether we possess the same constitutional courage to see it as they did. A collective gasp rippled through the chamber. Justice Samuel Alito sat completely still, the historical evidence having dismantled not only his arguments in this case but also the broader positions he had championed publicly for years. Several justices exchanged meaningful looks, recognizing the gravity of the moment they had just witnessed. When Crockett returned to her seat, there was none of the usual murmuring that follows a powerful argument. Instead, the Supreme Court remained enveloped in reverent silence, the kind that marks a rare convergence of legal precision, historical truth, and moral conviction. The aftermath of Crockett's historic presentation reached far beyond the courtroom. Her argument reshaped modern constitutional discourse and breathed new energy into the field of voting rights jurisprudence. Within days, legal analysts and national publications were dissecting what soon became known as the Crockett Brief, not just her oral argument, but the detailed written submission that supported it. The Harvard Law Review published a special issue examining the Reconstruction-era records she had uncovered, with even prominent originalist scholars acknowledging that her evidence revealed neglected dimensions of the 15th Amendment's original intent. What Congresswoman Crockett accomplished was extraordinary, wrote Professor Akhil Amar of Yale Law School in The Atlantic. She used originalist reasoning to prove that the true understanding of the Reconstruction Amendments offered far stronger protections for voting rights than modern courts have recognized. It was a masterclass in how historical research can reveal the living meaning of the Constitution. The full impact of her work became clear 3 months later when the Supreme Court announced its decision. In a surprising 6-3 majority opinion, Chief Justice John Roberts wrote for the court, with Justice Amy Coney Barrett joining in concurrence. The court struck down the contested voter ID law and introduced a groundbreaking standard for evaluating election regulations. When voting laws produce measurable disparities in access to the ballot, Roberts wrote, courts must apply heightened scrutiny to ensure the states' interests are both compelling and pursued through the least restrictive means possible. He emphasized that this rule flowed directly from the original understanding of the Reconstruction Amendments, which had fundamentally shifted the balance between state autonomy and federal responsibility in protecting the right to vote. The biggest surprise came from Justice Samuel Alito himself. Instead of issuing a dissent, he authored a concurring opinion, signaling a rare retreat from his previously rigid stance on state control of elections. While maintaining that states held substantial discretion over voting procedures, he conceded that the Reconstruction debates, illuminated more fully in this case than ever before, established real constitutional limits. When those laws hinder access to the franchise, observers across the legal community immediately recognized the magnitude of this shift. Nina Totenberg of NPR described it as the most significant transformation of voting rights doctrine in decades, while legal scholar Richard Hazen wrote that Crockett didn't just win a case, she redefined the constitutional conversation about voting rights. For Jasmine Crockett, the moment marked a defining point in an already distinguished career. While she continued her service in Congress, her constitutional expertise made her one of the most sought-after voices in ongoing voting rights litigation nationwide. Law schools across the country reported a sharp rise in applications from women of color, many of whom cited her performance before the court as inspiration for pursuing legal careers. What Congresswoman Crockett showed wasn't only legal brilliance, said Sherilyn Afeel, former director of the NAACP Legal Defense Fund, during a public conversation at Georgetown Law. It was the transformative power of bringing diverse experience to constitutional interpretation. Her background as a black woman from the South, combined with her legal training and public service, allowed her to uncover connections in our constitutional history that others had simply overlooked. The wider impact on judicial ethics proved just as profound. 2 months after the hearing, the Supreme Court unveiled the first binding code of conduct in its history. The new policy established tougher rules on justices, public appearances, and introduced stronger recusal requirements to prevent conflicts of interest. Although no justice publicly linked the change to Congresswoman Jasmine Crockett's argument, the timing convinced many observers that her powerful demonstration, showing how public statements could erode judicial impartiality, had played a key role in inspiring these long-overdue reforms across the country. State legislatures began re-evaluating their own voting laws with renewed attention to racial and socioeconomic disparities. Several states voluntarily amended their voter ID requirements to enhance accessibility while preserving security measures, explicitly citing the Supreme Court's new standard as guidance. Even among conservative legal thinkers, early skepticism of Crockett's strategy gave way to acknowledgement of its intellectual rigor. At a Federalist Society gathering the following year, renowned originalist Randy Barnett remarked, Crockett reminded us that true intellectual integrity demands following the historical record wherever it leads, even if it challenges our preferred interpretations. Her research into the original meaning of the Reconstruction Amendments deserves serious study from every constitutional scholar. Her approach, quickly dubbed the Crockett Method, became a model in major civil rights litigation. Law schools and university legal clinics nationwide launched new projects to uncover similarly overlooked historical materials that could shed light on constitutional issues in areas like equal protection, due process, and voting access for everyday Americans, particularly those in communities long affected by voter suppression. The impact was both tangible and deeply symbolic. In Jefferson County, voter turnout surged in the following election. Many first-time voters publicly credited the Crockett case for inspiring them to participate in democracy for the first time. This was never about partisan gain. Crockett explained in a PBS Frontline documentary marking the case's first anniversary. It's about ensuring that our Constitution fulfills its highest purpose, protecting the fundamental rights of every citizen, especially the right that safeguards all others, the right to vote. When Crockett returned to argue another case before the Supreme Court 2 years later, the atmosphere was noticeably different. Justice Alito engaged her arguments respectfully. Other justices referenced her prior historical research, and legal observers noted that the court's entire approach to voting rights questions had evolved in classrooms nationwide. Constitutional law professors began teaching the Crockett decision as a landmark case, emphasizing that her greatest contribution extended beyond the verdict itself. What she achieved was a broader understanding of the Constitution's living meaning. By reviving the voices of the Reconstruction framers, she helped restore a more complete vision of America's constitutional progress, one that recognized each generation's duty to expand democracy rather than restrict it. What began as a tense confrontation in the Supreme Court chamber had grown into something far greater, a national reminder that the Constitution is not a frozen document from 1787, but a living framework that includes the transformative Civil War amendments. Written to make democracy more inclusive, Crockett had not merely won a legal argument. She had reclaimed a constitutional vision that had been forgotten for too long. In courtrooms and classrooms across the nation, her final words became a guiding touchstone for discussions of constitutional interpretation. The framers of the 15th Amendment would recognize exactly what is happening today. The question is whether we have the constitutional courage to see it as clearly as they did. It was a challenge not only to the 9 justices who sat before her, but to an entire nation, a challenge that would continue to echo through American democracy for generations to come.